Welcome back, everyone. Veterans Dedicated VA employees, everybody watching, thank you so much for your support, for coming back where we talk about VA disability. Let's continue learning about VA disability as a new topic here. Let's address some of the appeals area a little bit more, and we'll be looking at appealing a VA disability claim denial. What are your options, veterans? What are your options? As always, I'm Attorney Matthew Lang, a VA accredited attorney. Years of experience with the VA, both inside and outside of the walls there, veteran myself. So let's get into it. So let's talk about first maybe some reasons why a VA claim gets denied. There's definitely a few different possibilities, but in order to keep it brief, one common reason is going to be a lack of evidence. Veterans, your claim again has to meet certain requirements underneath the rules and the laws that govern the VA when it comes to assigning service connection or evaluations at that, and effective dates as well to your conditions. So VA just may not have enough information. It can be that simple. They just don't have enough information, enough medical evidence, for example, or even information in your service records to either confirm in-service event or a current diagnosis or what it may be in those elements to give you the service connection. Maybe when it comes to an increase, they just don't have enough medical evidence to show that the increase is warranted. So it could be something that simple. I'm going to call it simple, and maybe it's not, but it's really simple, lack of evidence. So we're going to talk about how to appeal your denial there, veterans, when there's just a lack of evidence. We're going to go through that process as well. There could be unfavorable VA examinations in your file there, veterans, and that's going to go to that nexus element that we've talked about before, that link. Sometimes the VA examiners provide an opinion that they don't support your claim correctly. I found in my years with the VA, when I'm starting in 2008 and all the way to the present, that VA exam typically is a number one reason, maybe even the top five, a top five reason as to why a claim is denied because of the inadequacies of that examination. Maybe the exam opinion wasn't requested correctly. The terminology came back in was incorrect. Maybe the examiner didn't address the issue correctly that meets the legal guidelines. Maybe they were very conclusionary. Maybe they relied on their opinion as just their personal experience and not medical literature. Maybe they felt that the lack of evidence was the sole reason for making their opinion, which the courts again have said that is automatically inadequate. So it could be a number of reasons. Could just be a really unfavorable, bad C&P exam. Maybe it's an unfavorable exam and it's not inadequate. That still could be a reason for denial as well, because it could just be that examiner, that was the opinion based upon their knowledge, their understanding, their review of the evidence. As we know, second opinion could be totally different. Everybody's got a different level of understanding, level of knowledge, education, even if we work in the same field. So it could just be an adequate exam, actually, too. It was just unfavorable for you, veterans. Maybe that's a reason to deny at that point, but it's also a reason you may have an option to appeal. Either way, adequate or inadequate, it's a reason. Veterans, there could be errors in your application, why we need to appeal as well. Maybe there were some missing forms that were required that the VA didn't get. Maybe there's some incorrect information. Maybe there's some conflicting information. Maybe there's some clarity that was needed. Maybe there's incomplete evidence. It can lead to this denial. Something that we need to clear up. Now, ultimately, in a lot of things that I see veterans from my practice, and I'm going to see the bad and the ugly of the VA in most cases, is that the VA has just made a straight legal error when denying the claim. Maybe they failed to weigh all the evidence correctly. Maybe they didn't look at it all. Maybe they didn't give a proper analysis. Maybe they just got too much of a hurry, essentially. Whatever the error may be, there was a legal error in there, and we can go back and definitely appeal that. So you get options for appeal there as well. Again, there could be multiple different things that could lead to a claim denial, but those are just a few to kind of put out there and leave it brief for this video. So what do you do, veterans? What do you do when you get that denial? Now, think about this. Your denial could be, again, that service connection. It could be the evaluation that you're seeking for that condition. It could be the inappropriate or the belief of an inappropriate effective date assigned. That could be, in a sense, a denial if they're not, VA hasn't assigned the effective date back to where it's believed to really should be underneath the law. So you get some options here. So what are your options? Well, your first set of options, veterans, is either a supplemental claim, a higher level review claim, or an appeal or notice of disagreement to the Board of Veterans Appeals, also known as the BVA. Now, even that there has a few options, and we'll talk about that as well. So veterans, it really depends on what your reason for denial is. And VA is supposed to, underneath the law, write up a decision that is not conclusionary, that actually provides an understanding for you veterans to know why you are truly denied. Unfortunately, that sometimes is the error that we run into, and that I see in the bad and the ugly on my part, is the decisions narrative are very conclusionary. They're just system clicks canned text, and they don't give you any idea of really truly why you were denied. So sometimes it can be hard to figure out what the reason is and what appeal process you need to be underneath, whether it be the supplemental claim, the higher level review, or the Board of Veterans Appeals. But let's just say that we have some clear enough information there. The supplemental claim really is going to be the option you want, veterans, if you feel that there was a lack of evidence or the VA has identified a lack of evidence. Maybe we have, let's say, evidence that doesn't show a diagnosis. It lacks that element. But you veterans have been to treatment for that condition and you know there's a diagnosis. But those treatment records didn't make it into your file before the decision was issued. So you can easily provide a supplemental claim. It's an option you have. The supplemental claim is a opportunity now for you to submit that medical evidence that was missing from your claim. New and relevant evidence is what you can submit now to help support your case. Now, that's just one example for the use of supplemental claim. I will say that the supplemental claim, from my legal arguments, is not only bound to new and relevant evidence as the black and white piece of the law may state. Remember, there are exceptions in the law and other provisions of the law, which veterans could mean that you could use a supplemental claim strategically to address duty to assist errors as well. The VA cannot ignore those errors. If that's the only tool you have because the other options are out of play, VA cannot ignore the fact that they've broken the law. So I feel that can be addressed as well as a supplemental claim. But again, that's a strategy that I would talk about with your representative on how to fill. But your option is, again, a supplemental claim, especially if you have new and relevant evidence to submit. Now, let's say veterans, maybe that it's not a lack of evidence that was here. Maybe there was an unfavorable VA exam, and maybe that exam is believed to be inadequate, and maybe it really is. Like I said, it's one of the number one reasons of errors in the VA. Still, even today, from what I see, the VA, unfortunately, I'm sorry, VA. How much I love your mission and what you do positively for veterans. I do, again, see the bad and the ugly. And those exams are pretty much always bad when they get to my desk. So they're usually unfavorable, and it's been used because they're inadequate when they're unfavorable to make that denial. So that being a number one issue, usually we want to look at like a higher level review, veterans. That could be your strategy there. And that's the option you get there. And really what the higher level review is at this point, you get to tell the VA, hey, I don't have any additional evidence to submit because that's not the reason of the denial. You get to now argue the idea of, in this example, the unfavorable exam that's inadequate, and tell the VA, hey, we need somebody of a higher authority or to look at this claim and see if the evidence now actually should have granted, as it is, the the benefit, or maybe there should be a duty to assist error called. It should go back. So ultimately, the higher level review is just a review of the claim in itself without any new evidence provided. Now, the higher level review is written in to give you an informal conference, but I will also make argument to say that the law allows a hearing at any time, formal hearing at any time during the claims process, whether it be a supplemental claim or a higher level review. VA may not be very fond of me stating that, but I would say that the law does allow that as well. So veterans understand those are, again, strategic pieces that your representative, if you have one, may want to look at and doing. Sometimes myself, I'll admit I do it, sometimes I don't. We do run into a series of concerns and complications sometimes with that. I will also submit usually quick legal arguments as well, but there could be issues there as well. It just depends on what your strategy is and what the facts of your cases are and how we want to do it. Maybe we do both. Who knows? But the idea here is let's stay on track. Supplemental claim, new relevant evidence at this point, or high level review, to have the evidence reviewed as it is and granted as the evidence is, or maybe there is, again, an inadequate exam that needs to be redone and a duty to assist error needs to be called. And at that point, veterans, your option now goes back into a supplemental claim. So VA rules in general will say that you can have a higher level review on top of a higher level review. So if a higher level review gets denied, you can't, underneath their rules, apply to a higher level review. Now, there's some argument out there that says otherwise, but we won't get into that today. So the idea is that at this point now, the higher level review was submitted. If a duty to assist error is called, veterans, you back down a supplemental claim. So that higher level review becomes available again to you. So in a way, you're kind of a higher level review on a higher level review when you're not. So your options can change in the process at the same time. Now, maybe you've been through the supplemental claim lane, maybe through the higher level review claim a couple different times, a few different times. Maybe you decide strategically that's not the place you want to be. You do, veterans get the option right away on an appeal to go straight to the BVA, to the Board of Veterans Appeals. Now that is within the Modern Appeals Act now that you get to do that, and that's only been within the last, I want to say, probably almost, what are we running on, six years now. You got to be able to do that. That was never always the case. Is it a benefit? Yeah, I believe it is to the veterans. But again, give your representative and determine if it's the direction you want to go. So what's the Board of Veterans Appeals allows you to do is really a combination of what we've already been talking about. You can have a direct review by the board. You can select that by the board. Now, keep in mind that the supplemental claim and the higher level review claim, these are not legal professionals that make this decision. These are people that the VA has hired and trained off the street. Now, they may have a legal background or some sort of legal education, but not likely. So what's nice, in my opinion, about the BVA is that we get actual attorneys and judges for the first time that help make the claim. Does that necessarily make things better? Yeah, they can make mistakes too, but just understand if that's what you're looking for, is somebody with that legal background to really make that decision, you may want to consider the BVA. But again, veterans, just know, talk to the representative, determine what that proper strategy is. Even I don't go straight to the BVA all the time. But understand the direct review, though, at this point. There's no new evidence. It's kind of like a higher level review. There's no new evidence. There's no hearing. It's just a review of the file as it existed at the time of that submission of that appeal and the time of that original claim that's being appealed. They can only look at that evidence. That's it. Now, keep in mind at that point, they can do one of three things or combination thereof. They can grant the benefit off that evidence. And I do see that happen. Usually by the time I take it to the BVA, I'm taking it there because I feel the evidence is enough to grant. And the veteran should have 4, 5, 6, 7, 8 years ago been granted based upon that evidence. And we usually find them right, which is kind of nice. Am I perfect? No. So not all the time, but majority of the time that's the case. And that's all you need is a direct review. VA just messed up. They didn't apply the rules correctly. And these attorneys and judges will, but again, not always. Strategy you just gotta talk about. So your other option of veterans is in the BVA is that you get the evidence submission docket or lane as well. So this is kind of like a supplemental claim, except you're limited to a 90-day window to file additional evidence. So even if you feel there was a lack of evidence in the time that the VA denied your claim, you may want to go through the BVA at this time and submit that additional evidence for them to review on top of the the claim itself from like a direct review. So it's like a direct review plus an evidence window, and they'll review that evidence as well. Now, sometimes veterans, a hearing is the way to go, and you get that option as well in the BVA. You'll get an option of going to a hearing in front of a judge, whether it be virtual, in person, and giving testimony. And you can bring witnesses as well. They can give testimony as well. This will be a method of, again, providing testimony, and then you'll get the 90-day window. So, and then you get the direct review essentially in the back. So it just keeps kind of growing. It's kind of like if you go to a page for a subscription, they go, you get the basic, you get the elite, you get the VIP, whatever, right? So you're going to get the direct review either way. It's all in there. Evidence submission piece, you're going to get with the evidence submission part. Once you add the hearing part to it, you still get the evidence window as well. You get the 90 days after the hearing there if you choose not to waive it. But again, it's all strategic. So there's a lot of options, veterans. As I go through this, I mean, you get the options of supplemental claim, the higher level review, and that appeal to the BVA and those lanes. But there's still options within the options. Just kind of keep that in mind on how you move around. But it's all strategically based here, looking at the facts of your case. Now, if at any time, say the BVA fails to grant your claim there, veterans, and you feel that they messed up and they should have granted it, you still get other options. There's still other motions that can be filed and so forth, and different paths there you can take afterwards. But the big one that I want to mention today is you could have the option of going to a higher level from there. Now, this is not an option you get originally up front. This has to actually come from a decision from the Board of Veterans' Appeals from the BVA. You can ultimately take your case to the Court of Appeals for Veterans Claims, and this is CAVIC. Now, myself, I don't, at the moment, due to my workload, practice that high, but if we end up having to go that high, which is not something that happens very often to me, well, very, very rarely, understand that what's nice about having a representative on your side is we can usually refer to somebody who works solely in that area. They can definitely I can definitely refer you over there, and they can review your case and let you know. And we can get you set up with them as well, if need be. But the point is the CAVIC piece doesn't happen until after a board decision. There, it's not one of the options you get to go directly to right after a VA decision. And again, all the same reasons: errors in applying law, failure to consider evidence, inadequate examinations, whatever it may be. The reasoning is ultimately the same. I think for an appeal at that point, it's just that the decision comes from the BVA instead. You really only have 120 days of veterans as an option there to file a CAVIC case. Claim with the CAVIC after the BVA decision. That is one main difference between the other three options you get. You'd have a VA decision that denies, and you get that option of supplemental claim and the higher level review in the BVA. You actually have 1 year from the date of notification of that denial to file one in those lanes. But do know when a BVA decision is rendered and you want to attempt to take it to CAVIC, you do only have 120 days, not that entire year, to take it there. I highly recommend, again, veterans, when you get into the appeal world, especially BVA and CAVIC arena, to seek out an attorney representative. These are again, now we're talking more formal in the CAVIC. We're still kind of informal with the BVA, but we are talking more legalese. We're talking more judges. We're talking judges. We're talking attorneys, and you're going to get into a realm where I think it's better to have somebody who understands those rules. I know I've had veterans, not that I intended to do it to some of them, but got to hear just me and the judge go back and forth legalese and wait to see if we need anything from them. And we ultimately get the claim figured out and granted, which is nice. So I would recommend attorney representative veterans at the higher levels, especially. I would also still recommend on the lower levels as well. We can fight back and forth, take that stress off, and of you a little bit more, but you do have other options. VSOs are just as good. I've worked with a lot that are good, or other accredited agents as well that you can work with there. So in short, veterans, this is your options when your VA claim is denied. When it's denied for various reasons, you get these options. You get that supplemental claim option right away, the higher level review, and the appeal to veterans the BVA. You do get those options right away. They're within the first year of notification letter, the notification letter that goes out, the whole packet that comes into the mail for you. That's multiple pages, a bunch of attachments, and the decision in there. Would I wait a year? No, but you do get a whole year from there. And then do know that, hey, even if the supplemental claim is denied, you still get the options again of a higher level review, maybe even to the Board of Veterans Appeals. It's all based upon strategy and the facts of your case. You also say if a higher level review gets denied, you still get the board options, you still get the supplemental claim options, and so forth. The Board of Appeals say the BVA denies, you really can still come back down to a supplemental claim. Not really a higher level review at that point, but a supplemental claim, or you have a series of other options and motions that can be filed to reconsider with the BVA if those are appropriate, or you just go straight to the CAPIC and get that argued out there. Each one is an option for sure. So veterans, with that, I thank you for your service. I thank you for all your sacrifices that you have done. I thank you for the opportunity to make these videos and provide this information to you. VA, dedicated VA employees, I thank you as well for the hard work you do. I understand errors do happen. I do see the bad, the ugly. So I apologize if I feel like at times I'm beating you up, I promise. I do have a respect for the hard work you do as well. So I thank you as well. With that, don't forget to like, subscribe, share, put in the comments what you'd like to see topics talked about, what questions you may have that I can answer in an educational format. Again, not specifics to your case, as I don't know those facts. And if veterans, you want a free case evaluation, don't forget veteranlane.com to schedule that time with me. I do have a local office now in Surprise, Arizona, so if you are in the area and you wanted to sit down in person and chat, feel free to walk in, and we'll do that as well if I'm available. Otherwise, veteranlane.com. Thank you, everyone. Have a wonderful week, and I'll see you next week.